Honorable Mr. Justice P.R. Gavai, Honorable Judge of the Supreme Court of India and our Chief Guest for today, Honorable Mr. Justice Nitin Jamdar, Honorable Acting Chief Justice of High Court of Bombay, Honorable Justice M.S. Sonak, Honorable Justice M.S. Karnik, Honorable Justice P.P. Deshpande, Justice Anil Killor, Justice Prakash D. Naik, Justice Satish Ladda, Justice Valmiki Menezes, retired Justice and now a Senior Advocate, Mr. Dama Shashadri Naidu, Advocate Manan Kumar Mishra, Chairman, Bar Council of India, Advocate Jay Bhave, Member, Bar Council of Maharashtra and Goa and Bar Council of India, Shri Dinesh R. Shetty, Registrar Administration, High Court of Bombay at Goa, Shri Ram Subrai Prabhudesai, Registrar Judicial, High Court of Bombay at Goa, Advocate Devidas Pangam, Advocate General, High Court of Bombay at Goa, Senior Advocate Zilman Koel Pereira, the President of Goa High Court Bar Association, Senior Advocates, and my dear colleagues. It gives me great pleasure to extend a very warm welcome to all of you assembled here today as we commemorate 50 years of the Keshwanand Bharati Constitution Bench judgment of the Supreme Court of India and 40 years of the establishment of the High Court of Bombay at Goa. I now request the President of the Goa High Court Bar Association, Senior Advocate Mr. Zilman Koel Pereira, to kindly deliver the welcome address and to address this august gathering.
For today's function, Honorable Mr. Justice Gavai, Honorable Judge of the Supreme Court of India, the guest of honor of today's function, Mr. Justice Jamdar, the Chief Justice of this Honorable Court, Honorable Mr. Justice Sonak, Honorable Mr. Learned Advocate General, Advocate Gauri Shagni, Honorable sitting and former judges of this Honorable Court, Mr. Manan Kumar Mishra, I don't see him here, the Chairman of Bar Council, Mr. Jay Bhave, the Chairman of the Bar Council of Maharashtra, my senior and junior colleagues at the bar. At the outset, I must personally thank the Honorable Mr. Justice B.R. Gavai and our Chief Justice for having acceded to my personal request and for the first time given us the privilege of your joint presence at this august function. I must also thank each and every sitting judge present here for this occasion, as this occasion is also of significance to us as we are celebrating 40 years of the presence of the High Court of Bombay here. Today we feel part of you, seeing so many of the honorable sitting judges. Thank you, your lordships, for participating in our celebration. We thought of celebrating these twin events, namely the 50th anniversary of Keshwanand Bharati's case and the 40 years of the establishment of the Bombay High Court here, which was established as a common High Court for Bombay and Goa. In fact, to celebrate and commemorate the presence and the role of the judiciary in the country and the setting up of the High Court in this state as part of the federal structure of the country. Ours is a country, one of the few in the world, which has a unique constitution, a constitution which is a blend of American Constitution and the unwritten British Constitution, given the fact that the country was under the British rule and A.V. Dicey's rule of law was the rule in India as well. Our Constitution, in fact, was written in a document by the Constituent Assembly. The main architect of it being Dr. B.R. Ambedkar, who we should revere alongside the father of the nation. The fabric of Indian Constitution is the basic structure, and what we are celebrating today is the role played by the judiciary in upholding the basic structure whilst interpreting the Constitution. Article 368 of the Constitution gave a power to Parliament to amend Constitution, while Article 13 acted as a fetter to Parliament or state legislation from enacting any law which would abridge fundamental rights. As expected, as soon as the Constitution was put in effect and Parliament and legislature started functioning, the issue of validity of law came into being, and that is where the need of the hour was judicial intervention. The judicial intervention, in view of the constitutional amendments, can be classified into four broad periods. The first period began in 51, with Shankari Prasad's case, and ended in 67 with Golaknath's case. The second period began with Golaknath's case and ended in 73 with Keshavnand's case, rendered 50 years back, and which we are celebrating today. And the third period began with Keshavnand Bharati's case and ended in November 75 in Indira Gandhi versus Raj Narayan, which added a new dimension to the questions considered and decided in Keshavnand Bharati's case. And the fourth period began with Minerva Mills versus Union of India and Vaman Rao versus Union of India. The doctrine of basic structure of the Constitution is a judicially created concept, thanks to the Honorable Supreme Court, that restricts the power of Parliament to amend the Constitution, and this is found embedded by the Supreme Court first in Keshavnand Bharati's case, and thereafter interpreted to consolidate it in Minerva Mills' case. I do not want to encroach on the interesting and delightful speech which would come straight from Mr. Justice Gawai, Honorable Judge of the Supreme Court. But I would like to join this celebration with the well-known adage, 1,000 years scarce served to form a state, and an hour may lay in the dust. The second celebration, as I said, is 40 years of the existence of Bombay High Court in Goa. The precursor to the Common High Court of Bombay and Goa was the extension of jurisdiction of the Bombay High Court in the year 82, when we had senior judges of the Bombay High Court, to recollect a few, Mr. Justice Regate, Mr. Justice Jagirdar, Mr. Justice Varyava as he then was, Mr. Justice Barucha as he then was, Mr. Justice Landin, all of whom in fact sat here and delivered justice. On Goa becoming a state, the Common High Court of Bombay and Goa was set up, and the Bombay High Court started functioning as a Common High Court for Bombay and Goa. It was then, as you all know, functioning from the old Lyceum building, which was my alma mater till the liberation, where I began my studies and where I had the privilege of practicing my profession. We have had the privilege of having illustrious judges from the High Court of Bombay, as Mr. Justice B.R. Gawai, who is not a stranger to us, but whom we consider as a family member, for when he sat here, he not only rendered justice, but he was affable and encouraging to all of us. We then had also the privilege of having Mr. Justice Jamdar, the Chief Justice now, who sat here for a year and treated us all in a very dignified manner. Today, we have you both together sitting on this platform and reviving your and our past memories. Thank you, sirs, for gracing this occasion. The Goa High Court Bar Association was set up by no other person than the departed Senior Advocate Manohar Uskankar, who was its first president. Goa has also contributed its might after the establishment of High Court in maintaining the dignity and the prestige of this High Court. The Goa Bar has given 7 judges, and Goa has given altogether 12 judges to the High Court who dispense justice in an impartial and equitable way. Today, with the infrastructure which we have been provided with in the new building, we have adequate room and facilities for the bar, as well as litigants, and for the judges as well. But the infrastructure would not have been complete unless the bar was a developed bar to match the infrastructure. Let me tell you, sirs, that our committee, after it took over, and to match the infrastructure, which has been provided, set up and established the state-of-art library to help the members use it. Sir, let me tell you without bias, an insult to my designated senior colleagues, that today we have a very efficient and upcoming junior bar. I, as a president of this association, I am proud of it, along with my senior colleagues, as an encouragement to all of them and a hint to the new entrants without being shy for being in praise of my own bar. I say that this bar, sirs, would be encouraged by being in the bench. I do not mean that they are encouraged, who has been encouraged by the bench. I do not mean that they are not encouraged by the bench. Now that you, sir, Mr. Justice B.R. Gavai, a senior judge of the Supreme Court, and Honorable Chief Justice as well are here together, my ardent request to you, sirs, if I am not impertinent, is that more members of this young bar be recommended to the bench so that we could have them here in Goa to deal with local problems. Let me mention, sir, and I have made it known to the Honorable Chief Justice that the association has resolved that the High Court should have at least 5 members of the bar at one time adorning the bench. That's my ardent request to you, sirs, if I am not being indiscreet, so that the merit of the Goa bar is duly acknowledged, and also we have adequate number of judges on permanent basis to man this bench. Today, sir, we are releasing a souvenir. In fact, on commemoration of this event of our association, has an online magazine called On and Off the Record. This is a physical part of On and On the Record. The souvenir which we are releasing today, for the first time since the association has been established, has a nostalgic value, as it has a page dedicated to lawyers who practiced from the Portuguese regime in the High Court, a page dedicated to judges elevated from Goa, a page dedicated to senior advocates, which will remain in print in the pages of this magazine. It also carries articles from various members of the bar on various topics of interest. I think I have bored you for too long with my litany, and I am sorry for it now, sir. For now, it's time for me to sit down. But before I sit down, I would request the members here present to observe a minute silence for the departed soul of Mr. Vishnamkar, who was our senior advocate here and a senior.
I request Senior Advocate Salim Stalker to introduce our Chief Guest, Honorable Justice B.R. Gavai, Judge Supreme Court of India, and our Guest of Honor, Acting Chief Justice, High Court of Bombay, Mr. Justice Nitin Jamdar.
Dignitaries on the days, and my esteemed colleagues. Pleasant task of introduction of the dignitaries. As said by the earlier speaker just now, some people don't need introduction. As all of us know, my peers especially, Justice Gavai, as then he was the judge of Bombay High Court, he was here and we appeared before him. In fact, on a personal note, when I greeted him in the corridor, I said, I will come back. He said, you appeared before me. I was so happy. Well, friends, let me do my task. Justice Gavai was born on 24th November 1960 at Amravati, and he joined bar on 16th March 1985. He worked with late barrister Raja Bhosle, former Advocate General and Judge of the High Court, in 1987. He practiced independently at Bombay High Court from 87 to 90, and after 90 practiced mainly before the Nagpur bench of Bombay High Court in constitutional law and administrative law. He was a standing counsellor of Municipal Corporation of Nagpur, Amravati Municipal Corporation and Amravati University. He appeared regularly for various autonomous bodies and corporations like SICOM, DCBL and various municipal councils in the Vidarbha region. He was initially appointed as the Assistant Government Leader and Additional Public Prosecutor in the High Court of Bombay, Nagpur bench, and later was appointed as a Government Leader and Public Prosecutor from Nagpur bench. He was elevated as an Additional Judge of the Bombay High Court on 14th of November and became a permanent judge of the Bombay High Court on 12th of November 2005. He presided over benches having all types of assignments at the principal seat at Mumbai as well as benches at Nagpur and Aurangabad, and as said earlier, our bench. He was elevated as the judge of the Supreme Court on India on 24th of May 2019. Now, a short introduction of our Justice Jamdar, the acting Chief Justice. As said by the earlier speaker, he was here with us on 2 occasions, in 15 as a visiting judge, and thereafter again it is for a full period of 1 year. So both of us know each other, but again a short introduction. Justice Jamdar was born in Solapur into a family of lawyers, being the 3rd generation to pursue a career in the legal field. Having received education in different schools across Maharashtra, obtained degrees in commerce and law from Sidney College and Government Law College, Mumbai. Practiced at the Bombay High Court in diverse fields, primarily administrative and constitutional law. He represented various public bodies such as Jilla Parishad, municipal councils, municipal corporations and universities. Also represented the Bar Council of India and the High Court administration. Was appointed Senior Standing Counsel for the Union of India, and he was appointed the Judge of the Bombay High Court on 23rd January 2012. Pleased to present before you Honorable Justice Gawai, Judge Supreme Court, and Honorable Justice Jamdar, the Acting Chief Justice of Bombay.
We shall now honor our guests with a small memento. I request Senior Advocate Zilman Coel Pereira to kindly present a memento to Honorable Justice, Mr. Justice B.R. Gawai. Thank you, sir. I request Advocate Akshata Bhatt to kindly present a bouquet of flowers to Honorable Justice M.S. Sola. I request Advocate Simon Correa to kindly present a bouquet of flowers to Honorable Justice M.S. Karni. I request Advocate Gina Almeida to kindly present a bouquet of flowers to Advocate General State of Goa, Mr. Devidas Pandam. I request Advocate Sona Nishal to kindly present a bouquet of flowers to Honorable Justice C. Deshpande. I request Advocate Om De Costa to kindly present a bouquet of flowers to Advocate Manan Kumar Mishra. Unfortunately, he is not present. Very well. I request Advocate Om De Costa to kindly present a bouquet of flowers to Mr. Sangram Desai, Member of Bar Council of Maharashtra and Goa, and Bar Council of Mr. Justice N.J. Jamdar to deliver the introductory speech.
Honorable Justice Gawai, my esteemed colleagues, Justice Kemper, Mr. Pangam, Advocate General of State of Goa, Mr. Coelho Pereira, President of the Association, the office bearers, a member of the Bar Council of Maharashtra and Goa, senior advocates, members of the bar, members of the registry, ladies and gentlemen. Today we gather here to commemorate two significant milestones that have played an important role in shaping our legal system and advancing cause of justice. we celebrate 50th anniversary of the historic Keshwananda Bharati case, a landmark judgment that has left a mark on our constitutional framework. And we rejoice in completion of 40 years of the High Court at Goa, symbolizing its journey of upholding justice and serving as a pillar of the legal system in Goa. The 50th anniversary of Keshwanand Bharati's case holds an immense significance in our legal history. This landmark judgment, delivered by the Supreme Court of India, introduced the basic structure doctrine. It firmly established the notion that certain fundamental features of our Constitution and the core principles of our democratic framework are beyond the reach of amendment. Keshwanand Bharati's case not only set a strong precedent for the protection of constitutional values, but also emphasized the indispensable role of judiciary in upholding the sanctity of our Constitution. Keshwananda Bharati's judgment, with its emphasis on basic structure doctrine, serves as a guiding principle in understanding the limits of constitutional amendment and the preservation of fundamental rights. Also, the completion of 40 years by the High Court at Goa is a remarkable achievement worth celebrating. Over the past 4 decades, this esteemed court has emerged as a beacon of justice, tirelessly working towards ensuring access to justice to all in Goa, interpreting laws, resolving intricate disputes arising from conflicting jurisprudence. It has played a crucial role in safeguarding the rights and interests of the people of Goa, upholding the rule of law, and contributing to the growth and development of the state. As we gather here today to mark these significant milestones, it is crucial for us to reflect upon the journey we have undertaken and the challenges that lie ahead. We eagerly await the exposition from our esteemed keynote speaker, Justice Gawai, who will delve into diverse facets of this judgment. His analysis will provide us with deeper understanding of various dimensions of the ruling. In this introductory speech, I would like to speak on a different facet. That is the broader message coming from the judgment which goes beyond the law laid down. In the Keshwanand Bharati's case, all judges exhibited a remarkable dedication to the pursuit of justice regarding the differing perspectives they had. It is this underlying passion for justice over and above their individual legal position that I would like to draw inspiration from. This enduring quest for justice that transcends legal doctrine continues to inspire us to pursue justice in all forms. This will guide us to confront new challenges that have arisen 50 years since then. Therefore, to truly appreciate the significance of Keshwanand Bharati's judgment, in today's times, we must first acknowledge the prevailing challenges that shape our present reality. These challenges span various domains, including governance, constitutional principles, human rights, and social dynamics. By examining these issues, we can better comprehend the context surrounding the judgment and its implications in contemporary times. Today, in our modern world, we are confronted with three significant challenges. First, how do we preserve basic human rights while ensuring security and law enforcement? Second, how do we achieve development while safeguarding the environment? And third, how do we attain economic progress while leaving no one behind? These challenges demand our attention and collective efforts to find an equitable and sustainable solutions. As societies evolve and face newer realities, the interpretation and application of constitutional principles become paramount. It is incumbent upon us to adapt our legal system to meet the evolving needs of our society while upholding the values enshrined in our Constitution. Over the years, our legal system has undergone a significant transformation leading to dynamic landscape of justice. With each passing day, we encounter new challenges arising from disruptive forces of emerging technologies. From social media and online content to cryptocurrencies, drone aviation regulations, virtual reality, 3D printing, artificial intelligence, many advancements in the technology pose both opportunities and challenges to our legal system. While the basic challenges such as lack of nutrition, sanitation, education, infrastructure, climate change, etc. still continue to downcast. In the code, while advances on different fronts, complexities are giving rise to dispute which were never even thought of a mere decade ago. The areas from which dispute reach the courts are denser, complex and dynamic. While these technologies can create challenges, they offer solutions too. AI technology, for example, have potential to improve efficiency and effectiveness of our legal process, aiding legal research, case management and document analysis. However, as we embrace these advancements, we must ensure their ethical implementation, preserving the principles of fairness, transparency, and human judgment that underpin the judicial system. While AI can offer valuable support, it cannot replace wisdom and discernment of human judges. While harnessing technology, judiciary must remain steadfast in upholding the core principles of justice, ensuring that decisions are made with empathy, compassion, and deep understanding of the human condition. One of the pressing challenges that we face today are the mounting arrears of pending cases in our court. The delays in delivery of justice not only undermines public trust, but also denies individuals their rightful access to fair and timely resolution. Those in legal field must collectively work towards addressing these issues by advocating for reforms of case management, streamlining procedures, promoting alternate dispute mechanisms such as mediation. By embracing mediation, we can empower parties to find mutually agreeable solutions, reducing burden on our courts and promoting culture of amicable resolution. We must also recognize the importance of legal aid in ensuring justice to all. The provision of legal aid to marginalized vulnerable sections of the society is not just a moral imperative, but is also a constitutional right. It is our responsibility to make justice accessible to those who cannot afford legal representation. By strengthening legal aid initiatives, we can bridge the gap between those who need and the judicial system, fostering more equitable and inclusive society. However, as we address the challenges within our system, we must also recognize that justice is not solely confined to the courtroom. It is an entire ecosystem that extends beyond the four walls of the court. To draw an analogy, to promote healthier society, it is crucial to explore alternative approaches that go beyond administering medicine and surgical interventions. Similarly, rather than solely focusing on increasing the number of judges in the courts, it is also important to invest in preventive measures such as public awareness campaigns, education on legal rights and responsibilities, and early intervention strategies. By doing so, we can minimize the occurrence of disputes in the first place, fostering a society where conflicts are resolved through dialogue and understanding rather than through litigation. Ultimately, the final objective in any society is not only to create effective mechanisms to resolve dispute, but to create an environment where fewer people have to resort to mechanisms. This would require the involvement and collaboration of all stakeholders to work towards a litigation-free society. By promoting legal literacy and empowering individuals with their rights and responsibilities, we can have a society which our conflicts are resolved through peaceful terms. The justice ultimately is a comprehensive endeavor that encompasses principles of fairness, equity, and protection of individual rights. Therefore, as we gather here today to celebrate the legacy of Keshwanand Bharti's case, let us recognize that justice is not a singular act, but an ongoing commitment to creating a society that is fair, inclusive and just. As it is said, that justice is not a destination, but it is a continuous journey that requires our unwavering commitment and tireless effort. Keshwanand Bharti's case has placed an immense responsibility on the shoulders of the judiciary. With ultimate goal of rendering justice to all the citizens of the country, we need a holistic approach involving multiple stakeholders and institutions to create a society that upholds values of equality and respect for human dignity. On this occasion, I extend my heartiest congratulations to the Bar Association for organizing this function. I wish the association continued success in the years to come. I am deeply grateful for this opportunity to express my thoughts and perspectives. Thank you very much.
Since Mr. Advocate Manan Kumar Mishra, Chairman Bar Council of India, and Advocate Jai Bhave, Member Bar Council of Maharashtra and Goa and Bar Council of India, have just arrived, we would like to honor them with a bouquet of flowers. I request Advocate Stephanie to kindly do the needful. The keynote address for today.
Ramda, the Senior Administrative Judge of High Court of Bombay and Goa, and dear friend Mahesh Kumar, the Learned Advocate General, Sri Devidas Sangam, Sri Kohim Pereira, the President of Goa High Court Bar Association, Sri Agni, the Secretary of the Association, my esteemed colleagues from the Bombay High Court, present here, Justice Karni, Justice Akash Naik, Justice Bharat Deshpande, Justice Valmik Menezes, Justice Anil Kilo, my senior colleague, Justice Kemkar, who has come from Bhopal, and my last partner in the Bombay High Court, the then Justice Naidu, now Senior Advocate, the President of the Bar Council of India, Sri Manan Kumar Mishra, the Jai Bhave, Shri Kumar Sharma, the Sangram Desai, the senior members of the bar present here, and dear friends. Really a great pleasure to be with you on this auspicious occasion when we celebrate the completion of 40 years of the High Court of Bombay and Goa and the 50 years of the judgment of the Supreme Court in the case of Keshwanand Bharti. As rightly said by Mr. Pereira, that I had a very, very pleasant sitting at Goa. I consider it a very rare privilege that he has called me to be a family member of the Goa Bar Association. I am really grateful to him for considering me to be so. At the outset, I must pay my respect to Sri Manor Vijayakar, who is one of the founding members of the High Court of Bombay and Goa, an eminent lawyer in his own, and also an additional Solicitor General of India at Delhi, and who was one of the most respected members of the bar. When we celebrate 40 years of the completion of the High Court of Goa, we must remember the great contribution of the senior members of the Goa Bar Association, who have immensely contributed in development of law. I had the privilege of sitting here for a short period, and that during short period, I must confess that I could learn a lot sitting here. I still recollect Mr. Udavkar, Mr. DeCosta who is sitting here, Mr. Surendra Desai, Mr. Rotlikar, and of course Mr. Koil Baroda, who was still young at that time and still young even after 10 years. I recollect one criminal appeal which was argued based on circumstantial evidence argued by Mr. Revankar, and many, in fact, when I was told that the Mopa airport has been inaugurated and started, I jokingly said that I also have some contributions in the establishment of Mopa High Court, because I recollect we had decided hundreds of matters in that sitting when I was sitting with Justice Days regarding the acquisition of the land for Mopa airport. I must say that Goa Bar is one of the best bars that I have seen, I have heard. As one of our senior colleagues, Justice Bobde, used to always advise that whoever wants to be a complete judge, he must sit in Goa at least for a period of 6 months so that he can learn law from all the sides. The variety of litigation that you have here, the mining matters, the environmental matters, so many public interest litigations, they really help you to enrich yourself as a complete judge, as a complete lawyer. And therefore, when I got this opportunity, I must thank Mr. Pereira. He has been after me for almost more than a year to be part of this occasion, though I had come for some functions related to the International Law University being organized, being started by the Bar Council of Goa with help of Mr. Devidas Pangam, Government of Goa. I could not make it to the bar, though I could meet some of the senior members of the bar at private occasions for the functions organized by the university. I really feel privileged to be here with all the members of the Goa Bar Association. I congratulate you all on the completion of 40 years of the High Court of Goa. Insofar as the demand made by Mr. Pereira that there should be more elevations from the Goa, I fully support it, but it is not within my domain. So I convey his request to the acting Chief Justice, and whenever it comes to the collegium, to our collegium, I will say that we fully support it. I fully agree that Goa deserves at least 5 members, and I think that would have been fulfilled if one of the members of your association sitting in the 3rd row here would have not declined in 2013, and again when this is Dipankar Datta was persuaded him. Anyway, the loss of the bench is a gain of the bar, and I would really, the Goa Bar is a bar full of tall talents, so I will request the Honorable Acting Chief Justice to seriously consider the request of Mr. Pereira, and as Justice Sonak was just telling me that even before the strength of the Bombay High Court increased to 94, there used to be 4 representations, and therefore with increase in the strength, there has to be an adequate increase to the representation to be given to the members of the Goa Bar Association. With this, I would like to come to the subject on which I am asked to speak, that is celebrating 50 years of Keshavanand Bharati. Before I come to the judgment of Keshavanand Bharati, I think it will be appropriate to refer to the legal history. As all of us know that there was a long debate in the Constituent Assembly. The Constituent Assembly met for a period of more than 2 years and 6 months and debated. One of the articles which was debated with regard to the amending powers of the Constitution, there was a criticism from both the sides. The Constitution provided that an amendment to the Constitution cannot be carried out unless it was passed by half of the majorities of both the houses, and some parts or some of the articles of the Constitution could not be amended unless the amendment was passed by 2/3 of the majority of the members in both the houses, which shall not be less than half of the members. So Dr. Ambedkar was criticized from both the sides. On one side, he was criticized that the amendment, the power to amend, is too liberal, and on the other hand, he was criticized that the power to amend is too stringent. But he gave an answer. He said that the amendment, the Constitution which we are providing, cannot be static, cannot be a dormant document, because we do not know what shall be the needs of the future generations, and the future generations must be left free to amend the Constitution so as to meet the challenges that would arise in the coming years. But he said at the same time, we cannot permit the Constitution to be amended liberally, because today the Constituent Assembly is sitting as an independent body without having any political agenda, and therefore it will be providing a strong Constitution for the generations to come. And if we enable the Parliament to amend the Constitution liberally, then there is a possibility that a political party who is in a power would use it as an umbrella or as a weapon to put its political agenda into action. And therefore we find that immediately after the Constituent Assembly adopted the Constitution on 26th of November, which came into effect from 26th of January, there were certain judgments of this court in the case of Champakaran and so on, which gave rise to the very first amendment in 1951. In the case of Champakaran, the government of Madras, the then government of Madras, had provided for reservation for scheduled castes and backward classes. However, the Madras High Court set aside that view on the ground that it was violating of fundamental rights, and particularly Article 14, because it was discriminatory in nature. It was carried to the Supreme Court, and the Supreme Court, by a judgment of 7 judges, the Constitution Bench, upheld the judgment of Madras High Court, and it held that the executive or the Parliament does not have power to execute, to enact a law or to amend a Constitution in a manner which would abridge or infringe any of the fundamental rights as enshrined in the Constitution. But we also see that since the country had wedded to the principle of social and economic justice along with political justice, from 1947 to 1950, all the state governments in the country had enacted various agrarian laws, thereby abolishing jamindaris, protection of tenants, and so on, so as to ensure that the fruits of the democracy reach the bottom levels of the citizens of the country. These amendments were challenged in various high courts. Patna High Court had held such an enactment to be contrary to the fundamental rights and therefore set aside the Zamindari Abolition Act, whereas the Nagpur High Court, the then Nagpur High Court, and the Allahabad High Court had upheld that the legislature had such a power to enact the laws for agrarian reforms, since it was in tune with the directive principles of the Constitution of India. These contradictory judgments gave rise to the first amendment in 1951, which was tabled by none less than Pandit Jawaharlal Nehru himself. By the said amendment, Article 31A provided that, as all of us know, that initially Article 31 provided that the right to property is a fundamental right, and therefore by 31A the Parliament provided that the acquisition of lands, etc., would not be declared invalid on the ground that it infringes any of the fundamental rights in Part 3 of the Constitution. It also provided for Article 31B, which validated certain acts which were enacted in furtherance of the constitutional scheme of social and economic justice, that is agrarian reforms, and it also, for the first time, enacted 13 such enactments in the 9th schedule, which were enacted in furtherance of the policy of social and economic justice. This came to be challenged in the first case of Shankari Prasad Singh Dev versus Union, to which Mr. Coelho Pereira has referred to. It was argued that under Clause 2 of Article 13, there was a prohibition that any law which is in violation of fundamental rights would be invalid. However, in the case of Shankari Prasad, the Constitution bench negated the said challenge. It held that the provision under Clause 2 of Article 13 was only applicable insofar as the laws are concerned, and it did not affect the Parliament's amending power to amend the Constitution. Then, in the meantime, there were certain cases, because at that time, as all of us know, that Pandit Jawaharlal Nehru's policy of social justice involved acquisition of various estates, various lands, and there were 3 cases which were pending before the Supreme Court Constitution benches. The first one was State of West Bengal versus Subodh Gopal Bose, wherein the challenge was made that the acquisition which was provided, the compensation which was provided for acquisition of the Act was very meager, and therefore it was violating of Article 31 of the Constitution of India. Then there was a second case from Maharashtra, that is Damkadav Srinivas versus Solapur Spinning and Weaving Limited, wherein an enactment was passed acquiring the entire mill without paying any compensation thereof. And the third one was State of West Bengal versus Bela Banerjee, which also provided for bigger compensation for acquisition of the land. On all these 3 cases, the Constitution bench upheld the provisions to be ultra vires Article 31 and violative of the fundamental rights of the Constitution, and therefore hit by Clause 2 of Article 13. So this led to the 4th amendment to the Constitution in 1955, wherein Clause 2 of Article 31 was amended. It prohibited challenge on the ground that an enactment provided for compensation, provided for inadequate compensation, and therefore not hit by a right to property. Then Article 31A was also amended. Clause 1 substituted that any law which was enacted with regard to acquisition of the estates, etc., could not be challenged on the ground that it was inconsistent or contrary to any of the fundamental rights found in Part 3 of the Constitution. Then, the 17th Amendment in 1964, it enlarged the scope of estates and included Jagirs, Munafis, Jangam rights, Rayatwalis, etc. within the definition of estates. By the said amendment, 44 more acts came to be included in the 9th schedule. This came to be challenged in the case of Sajjan Singh versus the state of Rajasthan, and by a thin majority of 3-2, the said constitutional amendments were upheld. The 3 judges held that the power to amend the constitution was an inherent power, and therefore the parliament was entitled to amend the constitution, though it hit the fundamental right. But however, you could see that the seats of dissent were shown in the very same judgment in 2 minority judgments of Justice Hidayatullah and Justice Mudolkar. Justice Hidayatullah said that I would require stronger reasons than the ones expressed in Shankari Prasad to hold that the parliament has an unbridled power to amend the constitution. And Justice Mudolkar, he held that the power to amend, would it mean the power to substitute? He said that the power to amend cannot be used to take away the basic features of the constitution. So though we find that the term basic structure has been used subsequently in Keshavanand Bharati, the first time it was used as a basic feature in the judgment of Justice Mudolkar in Sajjan Singh. However, Justice Gajendra Dharkar, the then Chief Justice, speaking for majority, said that the Parliament was the best judge to take into consideration what was necessary with regard to socio-economic development of the country. There are various challenges that can be only understood by the Parliament, and therefore the Parliament's power to amend the Constitution cannot be fettered with. Then we find that in the meantime, 2 more enactments, one from the Mysore Land Reforms Act and the Punjab Land Reforms Act came to be included in the 9th schedule, and that gave rise to the judgment of IC Golaknath, which we popularly know as Golaknath's case versus the state of Punjab. In the said case, it was a bench of 11 judges, and by a thin majority of 6-5 judges, the said acts were held to be invalid on the ground that they hit Clause 2 of Article 13 of the Constitution of India. The learned 5 judges held that any act which takes away or infringes the fundamental rights or abrogates the fundamental right were not valid in law, and therefore the amendment to the Constitution which inserted those 2 acts was held to be invalid, whereas the 5 judges held that the Parliament has an inherent power to amend the Constitution, and it could also amend the Constitution though it takes away the fundamental rights of the citizens. Then there were 2 other cases which again were before the 9 judges case. One is Rustomji Cooper versus the Union of India, which is popularly known as the bank nationalization case, wherein the shares of the bank were sought to be purchased at a nominal price. And the second one was, as we all of us know, the case of Privy Purses, the case of His Highness, the Maharaja Dhira Madhavrao Jivaji Rao Scindia versus Union of India, wherein a challenge was made to the taking away of the privy purses of the erstwhile rulers of the princely states. Both these judgments held that the act which took away shares of the bank without paying adequate compensation, as well as the privy purse from the rulers, was violative of the Constitution, and set aside both these enactments. To overcome that, there were a series of amendments during the tenure of Indira Gandhi government. The first one was the 24th Amendment, wherein Clause 4 was inserted in Article 13, and a corresponding amendment was also made to Article 368, which provided that any law made by the Parliament would not be susceptible to challenge before the Supreme Court. And then the 25th Amendment provided for, it inserted Article 31C, which provided that any law made in furtherance of the social and economic justice as found in Clause B and Clause C of Article 39 would not be susceptible to challenge on the ground that it takes away the fundamental rights of the citizens. Then Article 31(2) was substituted. It provided that the Parliament or the legislature was entitled to provide for the principles on which the compensation for acquisition of the property could be provided for. Then, by the 26th Amendment in the year 1971, the Parliament amended the Constitution so as to take away the recognition granted to the princely states and so also withdraw the privy purses granted to them. Then by the 29th Amendment, two more acts with regard to state of Kerala Land Reform Acts came to be inserted in the 9th schedule. All these amendments over the last 2-3 years came to be challenged. In the case of Keshavanand Bharati, there is a little anecdote to which there are a series of petitions. The first one was by the Keshavanand Bharati, who was a Matadipati of one of the mutts in Kasaragod district, and the land of belonging to the mutt was being taken away by the Reforms Act. And since that was the first case, it was being referred as Keshavanand Bharati versus State of Kerala. It was argued by Nani Palkiwala on one hand and Mr. Sirvai, Mr. Daftari on the other hand. And every day he used to hear on radio his name, the Keshavanand Bharati's case, this is argued by Mr. Palkiwala, this is argued by Mr. Sirvai. He was afraid as to from where he will pay the fees to the lawyers. And unfortunately, we lost him last year. And this is one of the most important cases in the, rather than one of the most important case in the legal history of the Indian Constitution. It upheld the first part of 31C, wherein it provided that all laws made in furtherance of the directive principles as enshrined in Clause B and C of Article 39 would not be susceptible to challenge. However, the second part of the 31C, which provided that the Supreme Court or the High Court will not have a power to examine the constitutional amendments, was held to be ultra-virus the basic principles or basic doctrine of the Constitution. So also the similar amendments made to Article 13 and 368, which took away the power of judicial review of the Supreme Court, were also held to be invalid. It was held that the power of judicial review is one of the basic structures of the Constitution. You will find that the judgment in the case of Keshavanand Bharati, insofar as amending powers of Parliament are concerned, there was a vertical split. The 6 judges under the leadership of Chief Justice Sikri and 5 others held that there was an implied and inherent limitation on the powers of the Parliament to amend the Constitution, and the Parliament, even by an unanimous majority of both the houses, could not take away the fundamental rights guaranteed under the Constitution. Whereas, on the other hand, Justice A.N. Ray and 6 others held that there were no limitations on the power of the Parliament to amend the Constitution, and by amending the Constitution, it can abrogate, take away any of the fundamental rights finding place in Part 3 of the Constitution. However, it is the view of Justice H.R. Khanna, which he accepted a part of 6 judges on one hand and part of 6 judges on the other hand, which came to be a view of Keshavanand Bharati. He held that though the Parliament has a power to amend the Constitution and also to take away the fundamental rights forming part of Part 3 of the Constitution, it had no power to do an amendment or to enact an amendment which will hurt the basic structure of the Constitution, and therefore this is a milestone in the Indian history, Indian legal history, wherein Keshavanand Bharati held that though the Parliament has power to amend the Constitution and also to take away the fundamental rights, it had no power to damage the basic structure of the Constitution. Though no specific instances as to what would be found to be the basic structure of the Constitution have been laid down, but from the judgment we can gather several of the aspects. Some of them are the supremacy of the Constitution. The Constitution is the supreme document. The secular character of the Indian Constitution, the republican and democratic form of the government, then separation of powers of the 3 wings of the democracy, that is the executive, the legislature, and the judiciary, then the federal structure of the Constitution, as Mr. Coelho referred to, that we have, our Constitution is a mixture of American and British Constitution, but it is not only a mixture of American and British Constitution. We have borrowed good ideas from various constitutions, and though we are a federal structure like the United States, but our federal structure is much more unitary as compared to the American system, because American system, you have dual systems, dual citizenship, you can have a separate laws for the separate states, whereas insofar as India is concerned, we have only one citizen. Even if you are a part of, you are residing in Maharashtra or residing in Tripura, you are a citizen of India and not a citizen of Maharashtra or Tripura. Then the another basic structure was found to be securing the dignity of individual while maintaining the unity and integrity of the nation, then duty to construct a welfare state in accordance with the mandate of the directive principles of state policy, then building an egalitarian society. And we found that though certain principles were let down in the case of Keshavanand Bharati, post Keshavanand Bharati, in various other judgments, the concept of basic structure has been followed, has been strengthened. There are catena of judgments. Taking into consideration the paucity of time, it will not be possible to refer to all of them. I will be only referring to some of them. The first of such judgments, to which again Mr. Coelho referred to, was Indira Gandhi Nehru versus the Rajnarayan. In the elections held in 1971, Indira Gandhi had returned to the parliament. Her election came to be challenged by Rajnarayan, and the election tribunal, that is the High Court, set aside the election. Immediately after the elections, the Constitution came to be amended and clause 4A was inserted under Article 329A, and it sought to take away the powers of judicial review of Parliament insofar as the election to the post of President, Vice President, Prime Minister and the Speaker of the Lok Sabha. However, the said amendment was yet to be violating of basic structure of the Constitution by the Constitutional judgment on the ground that the Parliament does not have a power to take away the powers of the Supreme Court or the High Court of judicial review. Those powers are one of the facets of the basic structure of the Indian Constitution. And secondly, free and fair elections were also a part of the basic structure of the Constitution, and which provided any infringement thereof would be violating of the basic structure of the Constitution. Then the next case was Maneka Gandhi versus Union of India. The case arose out of the impounding of the passport of Maneka Gandhi. The court held that travelling abroad was one of the part of the fundamental rights of the citizen of India. And it also expounded that it is not necessary that the fundamental rights have to be written in Part 3 of the Constitution. It said that any right which could be evolved from a trinity of Article 14, Article 19 and Article 21 could be considered as a fundamental right, though not specifically written in the Constitution. And therefore we find that though various rights which have now been considered to be a fundamental rights, which were not considered at the time of insertion of the Constitution by judicial interpretation, have now been held to be a fundamental right: right to food, right to potable water, right to environment, right to pollution-free environment, are so many rights which the Supreme Court as well as the High Courts have evolved. Even before the Constitution was amended to include the right to education, the Supreme Court had held that the right to education up to 8th standard was a fundamental right of a citizen. Then the next important case is Minerva Mills versus Union of India, wherein the 42nd Amendment to the Constitution was challenged. Article 31C provided that was amended. Initially, Article 31C was it provided only saving of the laws which are made in furtherance of clause B and C of Article 39, but by the amendment, the scope was expanded and it included all the directive principles contained in Part 4. The Parliament wanted to protect all the all the laws which were enacted in furtherance of all the directive principles contained in Part 4 by a thin majority of 3-2. The Supreme Court disagreed with the amendment and it held that insofar as the provision with regard to 39B and C is concerned, it stood on a different pedestal, and insofar as the other directive principles are concerned, it stood on a different pedestal. Again, by a thin majority of 3-2, the said constitutional amendment was set aside. Justice Chandrachud set aside the amendment, whereas Justice Bhagwati in minority held that if 39B and C are one of the weapons for achieving social and economic justice in the country, so also the other directive principles contained in Part 4 are also a weapon for achieving the social and economic justice, and therefore there was no reason as to why such an amendment should be held to be ultra-virus. Then we have an interesting, in the subsequent case of Sanjeev Gop, just when Justice Bhagwati was presiding, sitting in a bench of 5 in a judgment delivered through Chinnappa Reddy, the said constitutional amendment was held to be invalid, we have now somewhat a peculiar situation wherein a 5 judges bench holds the amendment, 42nd amendment, to be invalid, whereas the another constitution bench holds the amendment to be valid. In the said case, Justice Chandrachud said that limited amending power is one of the basic features of the Constitution. He said that the Parliament cannot be permitted to have such a power to change the Constitution. Then in the case of S.R. Bommai versus State of Karnataka, which is an important case with regard to the federal structure of the Constitution, all of us know that the governors had dismissed various state governments in Karnataka and two other states, Meghalaya and Nagaland, and the Supreme Court held that the action of the governor in superseding this elected governments was contrary to the federal structure of the Constitution. It held that in our Constitution, though there is a tilt towards the union government, the union executive, at the same time, we cannot forget the federal structure of the Constitution. The states are not subordinate in our Constitution to the union. So this is one of the important judgments insofar as the federal structure of the Indian Constitution is concerned. I will shortly refer to some of the judgments which pertain to the independence of judiciary. So all of us know that it has been consistently held that independence of judiciary and separation of three wings, that is the executive, the legislature and the executive, is one of the basic features of the Constitution of India. In S.P. Gupta versus Union of India, that is one of the first cases, it is referred to as the first judge's case. It was sought to be argued that the predominance of the executive in appointment of the judges was violation of the basic structure of the Constitution of India. However, that argument was turned down and it was held that the predominance of the executive in appointment of the High Court judges or the Supreme Court judges was not violating of the basic structure of the Constitution. However, Justice P.N. Bhagwati, in his judgment, for the first time, mooted the idea of collegium. He said that the collegium was necessary wherein the recommending authority was wide-based, so also the consultation with wider interest was necessary. This will enable the appointment of the right kind of judges, which will again strengthen the independence of judiciary. Then there arose a second judge's case, the Supreme Court Advocates on Record Association versus Union of India in 1993. That is the judgment of 9 judges. Though in the case of S.P. Gupta, this court had held that the consultation does not mean concurrence. For the first time, in the case of second judge's case, the Supreme Court held that the consultation of Chief Justice of India would not merely mean consultation, but would amount to concurrence of the Chief Justice of India. It said that the term used, CJI, Chief Justice of India, in Article 124, should not be read only as the Chief Justice of India, and for the first time it evolved the mechanism of collegium. It gave the primacy of the appointment of the judges from the executive to the judiciary. It also set aside the view in the case of S.V. Gupta that President can overrule the recommendation of the CJI. And thereafter we know that as the executive was not satisfied with this judgment, a presidential reference was made in and that was decided in the third judge's case in the special reference 1 of 1998. And all of us know that again the 9 judges agreed with the view taken in the second judge's case, that is 1993 case. Only some modifications were made. Initially in 1993 case, the collegium provided the senior most judge of the Supreme Court and 2 judges, the Chief Justice of India and the 2 senior most judges of the Supreme Court, insofar as Supreme Court collegium is concerned, and insofar as High Court is concerned, the Chief Justice of the High Court and 2 senior most judges. The third judge's case provided that insofar as the appointment of High Court judges is concerned, the collegium would consist of the Chief Justice of India and the 2 senior most judges, and we therefore retained the position. And insofar as the appointment of the Supreme Court judges and the transfer of the judges from one High Court to another High Court is concerned, it expanded the collegium from 3 to 5, the Chief Justice of India and the senior most 4 judges, and therefore we find that these judgments have played an important role in ensuring the independence of judiciary. Finally, as all of us know, that the government brought National Judicial Appointment Act and amended the Constitution. That was also set aside by 4-1. The majority held that involvement of the executive in the appointment of the judges infringed upon the independence of the judiciary and also violated the supremacy of judiciary insofar as the appointment of the judges are concerned. It held that the separation of the judiciary from the executive was one of the important facets of the basic structure of the Constitution of India. And subsequently, recently, in the case of Roger Matthews and also Madras Bar Association, this court upheld that insofar as the appointments of the tribunals like the Income Tax Appellate Tribunal or the Central Administrative Tribunals or the NCLT, NCAT are concerned, the judiciary will have a pivotal role. The executive will not have a supremacy insofar as the appointments to the tribunals are concerned. So if that is permitted, that would amount to infringing the independence of judiciary. Then as all of us know that when the Central Administrative Tribunal as well as the Central State Administrative Tribunals were initially established, the Constitution provided that the decisions of such tribunals were beyond the scope of judicial review of the High Courts under Article 226, and directly an appeal would lie to the Supreme Court of India. The same was held to be valid in the case of Sampath Kumar by 5 judges. However, as all of us know that in the subsequent case of L. Chandra Kumari, the view taken in Sampath Kumar was overturned, and it was held that the power of the High Courts under Article 226 are one of the facets of basic features of the Constitution of India, and therefore any provision, any amendment in the Constitution or any enactment which takes away the powers of the High Court of Judicial Review under Article 226 were violative of the fundamental rights guaranteed under the Constitution. And therefore we find that an important role has been played by this court in maintaining the independence of judiciary. Lastly, the judgment of I.R. Coelho versus State of Tamil Nadu. Again, certain enactments which were inserted in 9th schedule were thought to be challenged, and this is one of the judgments wherein the Supreme Court, speaking in one volume, all the 9 judges speaking through Justice Sabrawal, held that as to whether the particular enactment was entitled to be inserted in 9th schedule or not was a matter to be decided on merits of each case, and it was to be examined as to whether the enactment enacted has a direct nexus or relation with the provisions contained in Clause B or Clause C of the Article 31C of the Constitution of India. Though all of us know that the case of Keshav Bharti is basically known for the establishing of basic structure doctrine in this country. The another aspect that also needs to be considered is that this is the first judgment which has played a pivotal role in marching towards social and economic justice as envisaged by the framers of the Constitution. As all of us know that prior to Keshav Bharti, the view taken by the Supreme Court in all the cases was that if there was a dispute between the fundamental rights and the directive principles, it is the fundamental rights which will prevail over the directive principles, and in case of a conflict, the directive principles will have to give way to the fundamental rights. But it is for the first time that though we find a vertical split insofar as the amending powers of the Constitution are concerned in Keshav Bharti, that almost all the judges have spoken with regard to an equal importance to be given to the directive principles and the fundamental rights. As has been held that directive principles and fundamental rights together and only together are the soul of the Constitution of India. As held in the case of Minerva Mills, Justice Chandrachud said that the directive principles and fundamental rights are like two wheels of the golden chariot of the Constitution of India. You span one wheel and the efficacy of the entire chariot will come to a standstill. And therefore, we find that the journey of our courts post Keshav Bharti, insofar as giving importance to the directive principles and marching towards the social and economic justice is concerned, has been very, very positive. We find that various labour enactments protecting the rights of labourers have been said to be valid by various courts in various judgments, even though they violated the fundamental rights of the citizens. In the case of Vijay Cotton Mills versus the union, it was thought to be argued that when a laborer is willing to work in my factory for 10 rupees, why should I be compelled to pay him rupees 15? The Supreme Court Constitution bench held that though you have a fundamental right to run the business, the labour also has a fundamental right to live with a dignity, and therefore an enactment which provides for minimum wages so that a labour lives with dignity will have to prevail over the fundamental right of a citizen to engage a labour at minuscule price. Subsequently, in Rupert Cross Rate versus Union, the Supreme Court also enlarged the scope of minimum wages and held that not only the minimum wages should not provide only for the basic needs, but it should also provide for the living conditions, housing, the education of the children, the medical expenses of the family, the clothing, etc. And therefore, a proactive role has been made by the Supreme Court in so far as the directive principles are concerned. We find that various enactments which were enacted by the state legislatures for protecting the tenants, for taking away the lands which were taken from the scheduled caste and scheduled tribes by the powerful people, and the distribution of the lands to landless have also been held to be valid by the high courts as well as various high courts as well as the Supreme Court. Sorry. Then you further find that before Keshavanand Bharati, or rather before N.M. Thomas, it was held that the reservation for the scheduled caste and backward classes, I referred to Champaran case. In Champaran it was held that the reservation was invalid and therefore it gives rise to amendment to the Article 15 and 16 of the Constitution of India, which provided for the Parliament to enact a law so as to make special provisions for scheduled caste, scheduled tribe and backward classes. And it was thought to be argued in N.M. Thomas that the reservations are an exception to the equality clause in Article 14 of the Constitution of India, Article 14 and 16. However, in N.M. Thomas, the Supreme Court rejected the said argument. It held that even if there were no special provisions under Article Clause 4 of Article 16 or Clause 4 of Article 15, still a special provision for scheduled castes and scheduled tribes and backward classes was permissible under the Constitution. It held that Article 14 does not mean equality amongst the unequals. It said that if all unequals are treated equally, it will only widen to inequality, and therefore a special provision which provided or enabled people who were for historical reasons outside the mainstream of the society should come in the mainstream of the society would not be violation of the Article 14. On the contrary, Article 14 would provide an unequal treatment to unequals so that they are equals. It was said that it is like providing a bicycle to a person to match a person who has already marched ahead and thereafter compete with him. And therefore we find that the judgment of Keshavanand Bharati has withstood the test of time for last 50 years. We are celebrating the Golden Jubilee this year on 12th of April 1973. It was delivered, and if we find that no, there was some criticism that it requires reconsideration, but it is the judgment in Keshavanand Bharati which has withstood that on one hand the basic structure of the Constitution has to be maintained, the federal structure of the Constitution, the independence of three wings of the Constitution, that is executive, the judiciary and the legislature, permitting them, each of them, to act within the spheres allotted to them, and on the other hand, it is also provided for a balance between the fundamental rights and directive principles of social policy, which have enabled this country to march towards the social and economic justice that is guaranteed in the Constitution. In the preamble itself, we have ensured to ourselves justice, economic, social and political. And therefore again I would, before concluding, refer to Dr. Ambedkar's speech, which I had referred earlier, the speech on 25th of November 1949, while presenting the final draft of the Constitution. He said that on the 26th of January 1950, we will be entering into the era of contradictions. He said that we have ensured or promised liberty, equality, and fraternity. He said that liberty, equality, and fraternity, not independently, but liberty, equality, and fraternity together are the soul of the Constitution. He said that if we provide for liberty, it will lead to laissez-faire. The stronger will overpower the powerless. If we only provide for equality, then there will be no initiative for a person to excel himself, and therefore liberty and equality together are the soul of the Constitution. And he said that for ensuring that liberty and equality live together, a fraternity needs to be there to act as a policeman, so that the liberty and the equality act together and within the limits as enshrined in the Constitution. And he said that we'll be entering into an era of contradictions on 26 January. On one hand, by providing one person, one vote, one value, we are ensuring the political justice. However, insofar as economic and social justice is concerned, we are on one hand, whereas economic justice is concerned, on one hand, the entire wealth of the country is concentrated into few hands, and the vast majority lives in the abject poverty, making it difficult to meet two ends in a day. Insofar as social justice is concerned, we have a society which is divided into four compartments, and such compartments which are so close that one cannot enter from one to another. And he said that if you do not make an attempt to eradicate these inequalities, then the edifice of democracy, which we have so laboriously built, will collapse like a house of cards. And therefore, in my view, Keshavanand Bharati, apart from underlying the importance of basic structure, has played a pivotal role in maintaining the social and, or rather developing the social and economic justice in the country.
First edition of the souvenir curated by the Goa High Court Bar Association. Dr. Shaheen, Secretary of the Goa High Court Bar Association, to propose the vote of thanks.
Good evening. I would start by thanking His Honorable Justice B.R. Gawai of the Supreme Court of India for agreeing to come to Goa once again, experience your revisit to the judgment, making us all have a flashback of the time when it was passed to now. It was really an enriching time, and it was a very educative talk. We did not realize how an hour had passed, and everybody was so engrossed in the talk. And one thing, sir, that we take away from your talk definitely was your art of addressing the gathering without even referring to the page before you. That is something which was worth noting. And I think it's a lesson for all of us as to how not only our talk is to be delivered, but justice also is to be delivered with the law in your mind so strongly set forth. Thank you, sir, for gracing us and also releasing the souvenir today. I would also thank the Honorable Acting Chief Justice, Justice Jamdar, for being here today amidst us and for also agreeing to have a sitting with us after adorning the chair of the Acting Chief Justice for the 2 valuable days that he spent with us with the bar, assessing the bar, patiently hearing our arguments, and also for the address that you have delivered. And I thank both Justice Gawai and Justice Jamdar for their kind words that they have given to this bar, for acknowledging the efforts of this bar for the last 40 years, for giving the due recognition to the bar. And if I may say, and if I can put it this way, we thank you in advance for considering the request of the President of the bar. I would also like to thank Honorable Justices Mahesh Sonak, Justice Makaran Karnik, Justice Bharat Deshpande. They've always stood by our side whenever we've thought of organizing any event in this premises, an event for the bar, an event for this institution. Justice Sonak has always readily lent us that helping hand as a senior administrative judge, and we have received that support even from the honorable sitting judges of this High Court. Thank you, sir, for being with us, for being behind us. I would also like to thank the registrars of this honorable court, the protocol officers, who have helped us in making this event a grand success. We know the difficulties that all of them face, including making sure that the electricity was restored in time. Thank you, B. Shetty sir, in particular. I would also like to acknowledge and thank Justice Anil Killor, Justice Prakash Naik, Justice Satish Radha, Justice Valmiki Menezes, retired Justice Khemkar, and former judge and now senior advocate Shri Dama Sheshadri Naidu for being present amidst us, for spending your time, and we look forward to having you with us also thereafter. I would also like to thank the members of the Bar Council of India and the Bar Council of Maharashtra and Goa for being here with us and gracing us with your presence. Thank you, sirs. I would also like to thank the senior advocates who have been present here today and who have contributed to the growth of this bar for the last 40 years and has helped the bar achieve the heights which have been duly recognized by every judge who has visited the state of Goa and have been sitting at this bar, at this bench of Goa High Court. I would feel in my duty if I don't mention some of our members of the bar who have made this event in particular a success, because we are also commemorating the 40 years of the High Court of Bombay at Goa. Commemorating this event, we have today released the souvenir, or the first souvenir which is launched by the association, called On and Off the Record. This souvenir which is released today, if you see, though it has the front cover of the new High Court building, the souvenir pens down the memories right from the Relasau to the present building in which we are today gathered here. It's a very interesting reading for everybody. It contains messages from the Chief Justice of India, the Honorable Acting Chief Justice, the judges of this Honorable Court. It also contains articles from learned senior advocates who have been practicing for the last 40 years at this prestigious institution. It contains articles from young lawyers. It also contains special pages dedicated to the lawyers who are practicing under the old regime and who continue to practice under the new regime. It contains pages dedicated to all those who have been elevated as judges to the High Court, and so on and so forth. This was a tireless effort, and I would completely be failing in my duty if I do not acknowledge the efforts of senior advocate Sri Ramchandra Ramani and his able associate Sri Nalin Mulgaonkar, who have spent a lot of time, they have spent their office hours and real dedication to make this dream come true a reality. I would also like to thank Mr. Harshvardhan Bhatkuli, who took this arduous task of compiling the entire material for this magazine and giving it the shape that we have today. I would also like to thank the publisher who agreed to publish this magazine for us. I would also like to thank all the advocates who are present here, who have travelled from Bombay, from other states, and who are gracing this occasion today. I thank the media for being a part of this event. I thank one and all who have been here and made this event a grand success. Pardon me if I missed out any name in particular. Well, let me have a look at the list once again. Well, I thought that I was missing out on someone. I was missing out the Advocate General, who has never said no to us. I saved him for the last. Not on the list though, but the Advocate General, whenever we've gone to him with any request for the bar, he's always said that I belong to the bar first and then to the government. And that's how he's been with us. Thank you, Devidas, for always being with us and always helping the bar for any cause. Last but not the least, no event is success without a good compare. Thank you, Neha, for agreeing to the request of the bar, for making the event a graceful event, and for conducting the event so successfully. I thank one and all. Have a great evening. Enjoy the monsoons in Goa. Have a great weekend. Thank you so much.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाये तब जय गाथा जन गण मंगल गायक जय हे भारत भाग्य विधाता जय